Have you recently seen that Geico insurance commercial that asks the questions, why is it that when people are in horror movies, they make stupid choices, such as running into the cemetery at midnight? Well, I think the ATF may be finding itself in a horror movie making stupid choices because with the stabilizing pistol brace regulation that they've just released, oh boy, I think they're going to have some problems enforcing this in court. We'll talk about it when I get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms and help us hit 100,000 subscribers. It will help us with the social media algorithms. All right, folks, I'm going to hit this generally. This factoring criteria, woo, sounds sexy, right? Factoring criteria for firearms with attached stabilizing braces. This is the pistol brace issue. The ATF has just issued their final regulations, and it is over 290 pages long. Yes, I will read it, but I know I have not read it yet. Only skimmed it because it's really long, and I will read it this weekend. In fact, I'm hoping to have some really good stuff for you over the weekend. So today on this video, I'm only going to hit what I consider the highlights, and I think some of the big problems that already appears obvious to me as I skim through the 293 pages of regulations that are being promulgated by the ATF. All right, so let's just step back and think about this for a second. So here you have, and here's the first problem the ATF's got. They have admitted on page 6 of their 293-page document, on page 6, they have admitted that in 2012, they signed off on pistol braces in conjunction with handguns and weapons, okay? Now, this is significant because the ATF is supposedly the intellectual giants, the technical experts, the gurus when it comes to firearms and firearms technology. Well, Seth, whether you believe that or not, that is the perception that judges will kind of assume to be the case when it comes to the ATF. Now, why is this actually good for us? It's because if the intellectual giants in knowing all about firearms technology back in 2012 and for many, many, many years thereafter found that adding stabilizing braces or pistol braces to pistols did not turn it into an illegal NFA item or anything of the sort. And now all of a sudden in the year of our Lord 2023 under the regime of Joe Biden, lo and behold, they've come up with an epiphany, a change of heart, a new understanding of the world that now these pistols with stabilizing braces somehow are NFA items and are somehow short barrel rifles that are illegal unless they are registered. We're going to get to that in just one second. Well, let me just tell you this. The courts in America, and I think even some of the Joe Biden favorable courts, are, I suspect, going to be a little bit skeptical about the fact that, number one, that the NFA has been around since the 1930s and the Gun Control Act since the 1960s. Somehow the ATF today in 2023, decades and decades after all of these laws got passed, somehow has a newfound understanding of what a short barrel rifle means when it comes to stabilizing braces. I think just on its face, it's going to cause judges to be skeptical of what's going on here. Now, keep in mind, now this is going to be one of these interesting issues where I think there will be skepticism against the ATF by both so-called conservative judges and so-called liberal judges. And what I mean by that is I think the conservative judges, conservative-oriented judges, are going to look at this and be like, A, this looks like this is an attempt to pass federal legislation through regulation, meaning shouldn't you go back to Congress and not try to do it through regulation? So I think conservative-oriented judges are going to be like skeptical. A, it looks like a backdoor way for gun control to try to get tens of millions of Americans thrown in jail for violating the NFA and federal law. number one. And number two, I think it's going to be viewed as regulatory overreach without congressional authority. So I think the conservative-oriented judges are going to look at this with a skeptical eye. But what's interesting, though, is I actually think there's a good chance that liberal-oriented judges are going to look at this with a skeptical eye as well. Because the one thing about the liberal judges is they often are sensitive to putting people in jail unjustifiably when it comes to these kinds of overreach. In other words, a lot of them are very sympathetic toward criminal defendants to making sure their rights are respected, as well they should. And I could see a lot of these sort of liberal-oriented judges looking at this and being like, yeah, well, maybe I personally like gun control. On the other hand, this seems to be a bit of a stretch that you get to redefine a federal statute in a way that criminalizes the activities of tens of millions of Americans, where you're just a regulatory agency and Congress should be the one criminalizing all this. And I think remember the other point, in addition to the fact that I think the conservative judges and the liberal judges are both going to look askance at what's going on here because of the way they are redefining what is a short barrel rifle to include pistols with stabilizing braces. I think that's the first major thing. The second thing I think that the judges are going to be looking at is like, look, what's going on here? We have read these regulations and they're really friggin' confusing because as the title of the regulations includes, the title includes factoring criteria. Now step back for a second. Do you know what factoring criteria means? It's not anything that you probably encounter in the real world, and you're lucky because of that. Factoring criteria has two words at its root. The first word is the word factoring. What does factoring come from? The word factoring comes from the word factor. Guess what? This regulation has multiple factors, the weight of which is unclear, and the number of which is unclear, and the definitions of which is unclear. And what I mean by this is it's a multi-factor, a multivariable test to determine whether or not something is a short barrel rifle, meaning a pistol with a stabilizing brace, is somehow converted into a short barrel rifle. It's not a clear definition. It's a multi-factored test. Different factors weighed different amounts. Like how many factors do you have to win? Does the government have to win one factor or two factors or three factors or 2 out of 3 factors? How does all that work? These different factors. So the first thing is that whenever you're dealing with a multi-factor test, it becomes very confusing right off the bat, which I think is going to be a real problem these courts are going to have in interpreting and applying this and upholding this and saying, ATF, this is just too complicated. If we have problems understanding it as federal judges, we don't see how ordinary Americans are going to be able to understand this. And that goes to the second word, criteria. A criteria is the standard by which something is measured. And they're going to be like, we can't figure out the criteria because it's confusing. This multi-factoring test is too confusing for us as courts or for lawyers. How on earth are ordinary Americans going to understand what these factors mean and whether or not it applies to them? Now, this is a huge deal in favor of the Second Amendment community because of a Supreme Court case that I'm not sure the ATF even paid attention to, but a Supreme Court case called Staples versus the United States. Staples versus the United States was a critically important case interpreting the National Firearms Act. Specifically in that case, there was a criminal defendant, Mr. Staples, who had a firearm that he thought was a semi-automatic firearm. So he thought it was a semi-automatic firearm. However, when the ATF arrested him and took his gun, the ATF testified that they, as the ATF, were able to take Mr. Staples' firearm and shoot it fully automatically. And therefore, the ATF says that Mr. Staples had possession of a fully automatic machine gun. And therefore, he has to go to jail. Now, Mr. Staples says, I don't care what you, ATF, was capable of doing with this gun. I'm telling you, I did not know it was capable of fully automatic fire. I thought it was just a routine, ordinary, semi-automatic gun. The fact that you can make it do that doesn't tell you anything about what I knew. And the Supreme Court agreed with Mr. Staples. The Supreme Court says, yes, if the government wants to put you in jail for violating the NFA, the burden is on the government to demonstrate that the individual criminal defendant knew, had knowledge, intended to possess, to know he possessed or she possessed a illegal firearm that violated the NFA. In that case of Staples, that the individual defendant knew he possessed a fully automatic machine gun, which he really didn't know. So the government says we don't have to prove knowledge, but the U.S. Supreme Court says, yes, you do. Now, the reason why this is critically important and very good news as I see it, not just for, individual Americans if they ever get caught up in this nonsense, but also for the litigation challenging the ATF regulation here, is because if you apply Staples to these stabilizing braces issues, right, Staples says that the government has to show that you knew you had an illegal short barrel rifle, right? So under Staples, the government has to show that you knew you had a stabilizing pistol brace of such that it was an SBR and therefore had to be registered under the NFA. But again, they're going to have to prove that you actually knew that you had one of these guns that violates the NFA as defined by the factoring criteria, which is multiple factors of different lengths, different weights, different criteria, different measurements. Who knows what all this means in the real world? And I think it's going to be very difficult to show that anybody knows that they violate this law, because I don't even think people trying to understand this law are going to be able to figure this out because it's so ambiguous and confusing. So I think that's going to be very favorable if there's ever a criminal prosecution of these cases. But more importantly, I think when this observation is made to courts, when they are challenging, when people are suing to challenge, which is going to happen, these regulations as unconstitutional, as illegal for a whole host of reasons, I think they're going to point out that no one even understands what this stuff means. And if lawyers can't figure it out and the judges can't easily figure it out, how is an ordinary person going to be able to figure this out to make sure they stay lawful and they stay out of prison? And remember, the penalties here are you go to prison. I mean, I think the penalties for violating the National Firearms Act is something like 10 years in prison potentially with a $100,000 fine. So it's a really, really big deal. So again, I think the fact that the Staples case, when combined with the factoring criteria language of this regulation, is ultimately going to be very favorable to us. But I also want to note, remember, we just won in the Fifth Circuit Court of Appeals in the Cargill case, the bump stock case. The Fifth Circuit Court of Appeals just said that bump stocks, that the ATF lacks the authority to define bump stocks as a machine gun. That's something only Congress can do. And I think, in my view, that if the ATF cannot win a bump stock case, which is extremely technical in terms of the bump stock, the rate of fire, making a semi-automatic fire like an automatic, right? That's much more complicated and in some ways more intuitive in favor of the government's view, because the truth is, if you take a bump stock and you put it on a semi-automatic rifle and you use it, it does usually increase the rate of fire over what it would be if it's just a semi-automatic for most people. So there's some common sense lethality arguments that I could see a judge saying, I at least understand the concept of what ATF's trying to do with bump stocks. But that kind of logic simply is not present when it comes to these stabilizing braces. Because these judges are going to look and they're going to be like, this is a gun. Okay, it's a gun. And they're going to look at a stabilizing brace and be like, okay, it's a brace. So when I combine these two things, how does this make the gun more dangerous? How does this make the gun more lethal? What exactly is a stabilizing brace do that makes this gun somehow more scary or dangerous and justifying being treated as an NFA item? And I think these judges are going to be like, we don't get it. What's the big deal? Why are we wasting our time with any of this ATF? And the answer is, we know what the ATF's trying to do. They're trying to harass gun owners. And the last point I want to make is, let's step back and remember why short barrel rifles were inserted into the National Firearms Act to begin with in the 1930s. When the National Firearms Act was drafted, handguns were originally in the National Firearms Act. Handguns were going to be NFA items originally. They were written into the statute. Somebody pointed out, someone is going to be able to get around the handgun NFA ban if simply by taking a rifle and cutting it off, and now you have a short barrel rifle. So because handguns were originally in the National Firearms Act draft statute in the 30s, they wrote in the language about short barrel rifles being NFA items to avoid people getting around the handgun ban by sawing off rifles or getting short barrel rifles. So they put the short barrel rifle language into the National Firearms Act. But then what happened was the handgun ban language came out of the National Firearms Act in the 1930s before it passed. But nobody pulled out the short barrel rifle language. So you have this kind of accident of history allows the short barrel rifle language to stay in the National Firearms Act. it. And now you have the ATF messing around with some nonsense, non-public policy consideration. I mean, how many people use pistol braces to rob a bank? Don't even, has that ever even existed? Has that even occurred? I have no idea what these people are talking about. Nevertheless, I think what's going to happen ultimately is clearly this is going to get challenged all across the country. Probably the most favorable courts are places like down in Texas in the Fifth Circuit, where you already won on bump stock cases. So the lower courts are going to have to follow that bump stock ruling in Cargill, which is a very favorable ruling for freedom and a very bad ruling for the ATF and regulatory overreach, where they try to use regulations to basically define or redefine or alter or expand federal statutory law, which they're not allowed to, right? Congress is only allowed to do that. The ATF cannot do it. So I think there are going to be some favorable court rulings. Again, we will only time will tell. We don't know how this is going to play out. Remember, according to the regulation, no one has to register their NFA item, at least according to this. They have 120 days after the publication in the Federal Register. I don't know when that has occurred or going to occur. I just don't know. But you have 120 days, at least according to what it says here, to register your item. And that's going to give rise to my final point is, by the way, the ATF does not have authority, as I see it, to allow for the registration of these firearms, because under the National Firearms Act, you can only register weapons or arms or objects if A, you're going to make one, then you get to register it, or B, you're going to transfer an already registered item to something else. Those are the two instances where you can register. So here you have the ATF saying, go ahead and register your pistol stabilizing braces, your pistol braces and all that. Go ahead and register your guns now under this authority. But here's the interesting thing. I don't think the ATF has the authority to allow people to register after the fact their firearms with the NFA. So this could be a problem, because I don't even know if they have the authority for the remedy they're proposing. Now, there is an example in the 1990s where something like this occurred. There was a handful of shotguns. I think there's 2 or 3 types of shotguns which were reclassified in the 1990s from being just ordinary shotguns to destructive devices. And those shotguns were indeed registered. You could register those shotguns under the NFA or with the NFA. You could do that. And that kind of happened. But I think that was like a handful of examples, and no one cared because it wasn't a big deal. It wasn't a big number. It wasn't anything too crazy. People just went along with it because it didn't matter. But here we're talking about with these pistol braces. Tens of millions of Americans are going to get sucked up into this, and I don't think the courts are going to stand for this, is my guess. Only time will tell, but I think that bump stock precedent, which I think that Cargill case is going to go to the Supreme Court and be heard next term. I think that's going to slap the ATF around big time, and I think the precedent based on that Cargill bump stock case is going to be used big time against these pistol brace regulations, but again, only time will tell, and we'll be covering this story more and more in the future because it's such a hot topic. Okay, hope you learned a little bit something here at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you soon here at the Four Boxes Diner.
Orders up. Table 2A.